You just wait a moment. Sharing my screen. We're expecting quite a few people today, so I'll just give it a couple of minutes. Just checking the clock. So it's 1 minute past 1. So we should probably get going. So welcome everybody. So it's mid-August. It's peak holiday season, and one would expect that most of us are out camping or holidaying in some other way. But we are definitely very thrilled to have such a solid interest in this webinar. We've got close to 150 people signed up. The webinar is on risk management, liability, and waivers. The webinar is, as you can see, it's recorded, and the recording will be shared with all of you afterwards, along with the presenter's notes. My name is Louise Peterson, and this webinar is hosted by the Outdoor Recreation Council of British Columbia. I am joining you from Revelstoke, which is in the territories of the Sinixt, the Silks, the Secwepemc, and the Ktunaxa people. So just very briefly about the Outdoor Recreation Council, we are a charitable organization with more than 60 organizational members spanning the entire spectrum of outdoor recreation user groups. We work to promote and advocate for access to and the responsible use of BC's outdoors for public recreation. We build bridges between outdoor recreation user groups and represent the broad interests of this community to government. And as always, I would like to extend a very warm invitation to all of you to join this one-of-a-kind organization. As a member or donor, you provide direct support for important initiatives such as these monthly webinars. So before we get started, I'm just trying to kind of find my. Before we get started, I've got a poll, and I'm just going to see if I can find it. I may need to, I'm sorry, I need to stop sharing for a moment just to kind of orient myself here. We would like to know a little bit about, to find out where you are all from today. Yeah, if you can just kind of tell us a little bit about yourself. Are you with a recreation group, like a potential ORCBC member? Are you with government? Are you a student? Are you with an Indigenous organization or Indigenous government? Or are you just somebody who loves to learn the inner workings of risk management and liability? So I don't think you can see this, so I'll just give you tell you in a moment what I see, and it won't take long. So we've got, a couple of people from the provincial government. We've got 16% so far from regional government, 10% from municipal governments, and 63 from recreation or conservation organizations. So I think, so that was interesting, at least for me to know. So I'll just end this poll. Oh, I guess I can share it too, if you want to kind of see it. So I'll just stop that. Okay, we'll get back to the presentation. So I'll just. So as a recreation organization or some government entity too, you are exposed to certain risks and liabilities, and this is why risk management needs to be a key priority for you and your team. Risk management is not the same as insurance, and we'll actually cover insurance at a different webinar in the fall. So while insurance insurance pays for damages if the risk was to occur. Risk management provides a clear and structured approach to identifying and addressing risks. So there are certain proven risk management practices that organizations such as yours can take to minimize their exposure to risk, including actions that minimize the possibility of damage or injury, minimize the impact of an accident, or actions that transfer liability to the user. So risk management is a very big field, but today we'll hear more about how liability waivers should be an essential part of your risk management strategy. So while liability waivers are relatively simple documents, they must be drafted properly and administered properly for them to be held up in court. So we are joined by Ryan Morasiewicz, who is an outdoor adventure and insurance defense lawyer with the Sound Law up in Squamish. He has extensive knowledge in risk management in the outdoor industry, insurance, injury litigation, health law, class actions, and corporate commercial liability. And we are absolutely thrilled that Ryan can join us today. So just before, so Ryan, feel free to kind of start sharing. I'll just stop this one. So after the presentation, we'll open up for questions. So feel free to post any of your questions now, but we'll take those after Ryan's presentation. Thank you.
Great, thank you, Louise, and thank you everyone for joining us today. Good afternoon. Just to warn you, there's a thunderstorm that is approaching where I am right now. I'm in North Van. So if you hear some rumblings in the background in the next 20 or 30 minutes, according to the radar app that I've been watching on my phone, I've got a big thunderstorm cell heading my way. So there might be some booming in the background. I apologize for that if it does happen. As stated, I'm a lawyer with Sound Law in Squamish, where I practice outdoor adventure law and insurance defense litigation. And in my spare time, as much as I have it, I'm a member of North Shore Rescue for search and rescue, and I have a wilderness search dog that I have validated with the BC Search Dog Association. So I personally see risk in a number of different facets or from a number of different angles. One, dealing with the consequences of it in my professional life, and two, managing and dealing with the risk in my avocation life in search and rescue. So today I'm going to talk about two main things. First, just a general or a quick primer on risk management. What is it? Why do we have it? What are the general components? But the bulk of the talk will be about one particular component about risk management, specifically liability waivers, why you should use them, should you even bother with them, how do you do them, and a few related things to keep in mind. Everything we do involves risk to some degree, not just any outdoor activities, but any activities. And I think it's a fair comment that some things are far more riskier than others. So all outdoor activities can and do involve risk of some degree. The level of risk will vary. Anything from lead climbing up a mountain versus walking along a river. All of those things have risk involved, but a certain amount of risk vary depending on your activity and what you're doing and who's doing it. I think it's also a fair comment that you can't eliminate all risk other than just not doing the activity at all, but you can take steps to reduce risk. Well, and why would you want to do that? Well, there's the ethical. It would help to reduce the chance of injuries occurring during something you're doing, either injuries from your own staff or from participants that you're hosting. But also there's the legal aspect of it to protect your organization. If you prevent injury, you prevent possible lawsuits against you. Now, I think different people will tell you about different elements of what goes into a risk management program, depending where you're looking, depending who's talking. But it's fair to say that there's probably about 7 broad categories that will provide a good, thorough summary of what is a risk management program or what is in a risk management program. The first point is how much risk is actually suitable or appropriate in the particular activity that you're dealing with. Now, there's a different risk exposure that's acceptable in, say, a learn to hike program for a group of 10-year-olds versus the certification exam for professional mountain guides. Risk tolerance and what you're willing to accept in your program or your activity depends on what the program is and who the participants are, based on their age, their expertise, their abilities, their training, and so forth. Identify the hazards that you're dealing with in your activity or your program. And now we're talking about both activity-specific hazards, For example, canoeing hazards are going to be different than skiing hazards, but also general hazards. And think the whole activity. So for example, driving or your transportation to the start of the activity beyond the outdoor adventure activity that we're talking about. And even within each activity, there's going to be different hazards. For example, the hazards of top roping in rock climbing are going to be different than the hazards of lead climbing in rock climbing. And also, when you're thinking about what hazards are possible in your activity, you have to think broadly. Lack of communication could in of itself be a hazard, especially when combined with another hazard. So for example, what happens if an injury occurs in an area of no cell reception? And also keep in mind, some hazards change. The weather is a good example. Hazards on a sunny day versus the hazards of a thunderstorm versus hazards of a minus 30 degree blizzard. Next, you evaluate the hazards. Are they even acceptable to have in your event? If their impact can be reduced, is the reduced impact hazard acceptable or not? Sometimes it's just too hazardous. Sometimes it's not. Control the hazards if you can. Now, if you can't eliminate a hazard, how can the hazard be minimized to either reduce the likelihood of them happening and or if they happen, reduce the impact or the consequences of the severity of the thing? Next, how are you going to finance the response to an event? Now, if something bad happens, who's going to pay for the response? Both the resolving the immediate issue response, but also the consequences, resolving the long-term impacts of the event. Some may choose to do it out of their own pockets. It's basically self-insurance. Others would choose for actual insurance. That's a pretty common thing. But something to keep in mind, you need to ensure that the insurance you get is appropriate for the circumstances that you're dealing with. And that's when you should really be talking with your insurance broker. And I understand there's going to be a future talk with an insurance broker, which I think is a very good one to attend as well. Just by way of an example, my wife and I climbed Aconcagua a number of years ago. In an international trip, we needed medical and evacuation insurance. But not just any insurance, we needed stuff that covered the particular circumstances. We needed insurance that covered both mountaineering, but not just any mountaineering, but it was mountaineering above a certain altitude, because there were exclusions in a general mountaineering evac policy that said we don't cover anything over X amount of meters. So you need to really consider what you're dealing with in terms of your activity, what your hazards are, to make an informed choice of what insurance you need to make sure that the insurance is going to cover your activity and what you're dealing with. Now, when we talk about insurance, virtually every, if not every, insurance company is going to require the use of a waiver, which is going to be the bulk of this talk. But continuing on for risk management elements, after you've arranged for or figured out how you're going to finance the response, you should be preparing for an accident response. Pre-plan for how to respond when something bad happens, what procedures to follow, make sure the first aid is appropriate and arranged. People know who to contact, how the communication is going to work. If there is no cell reception, what are you going to do? Generally, make sure that there's a plan for evacuation to a higher level of care, which is basically the ambulance. Are you confident and do you know that those in charge, both at the scene of the event and even back at the office or in the administration, know what to do when something happens? Do they have the proper training? Is it proper equipment on hand? Are the proper procedures set out and clear? And then carry out your accident response. That's pretty much self-explanatory in terms of when it happens, but it's also very valuable to do basically a tabletop exercise to see how everybody responds. Identify your weak areas and where you can improve for when the actual event happens, you're ready to go. Now, with that very, very basic high-level primer of a risk management or risk management plan, I'm going to now concentrate on one specific part within the finance accident response aspect, and specifically in insurance, where the liability waivers will come into play to help protect your organization. Now, backing up a little bit, why would a liability waiver be used and in what context? Well, just imagine a situation. Your organization hosts or leads an activity or there's an event on your premises. And then what I call something bad happens. There's an accident leading to either injury or death. There's either a lawsuit or at least the threat of one from the injured person or their family. Now, they would be suing or threatening to sue in what we lawyers call tort, And tort is basically just a wrongful act or omission that leads to civil liability. If they're suing you in negligence, you're being negligent. And they're looking for compensation, which is basically money. And if you have a liability waiver, that waiver can be a part of your defense to any such legal action or threat of legal action. Now, I said something bad happens. In other words, somebody got injured or died. Now, generally speaking, that can happen in two very broad ways. What happened was either the result of the natural risk of the activity in question, whether or not work was done to mitigate that risk, or what happened was the result of the negligence of the activity's host or their employee. Now, an example of the first one, say, let's pick whitewater rafting, for example. Exposure to fast water and waves is arguably a natural risk of the activity, whitewater rafting. In contrast, if a raft guide doesn't follow procedure and doesn't screw in the raft's drainage plug and the raft sinks in still water, any injuries resulting from that are arguably the result of the negligence of the host or their employee, and that is not a natural risk of the activity. Another example might be a zip line, for example. A natural risk of the activity of zip lining could be going down the line at high speeds and maybe having a slight muscle strain in your neck as a result. An injury that happens when the employee at the top of the zip line doesn't fasten the customer's waist belt or harness properly, and as the customer is going down the zip line, the harness unravels and the customer falls from the zip line. You know, having your harness unravel in the middle of the zip line is arguably not a natural risk of the activity of zip lining, and that's the result of the negligence of the host or the employee. And that distinction, the natural risk of the activity versus the negligence bit, is actually kind of key here, and I'll explain why. So that's something bad that happens, that's a risk that is that naturally part of the activity. We call that inherent risk of the activity. And it's important because the Supreme Court of Canada has said that if an injury is a consequence of the inherent risk of an activity, then the host or the operator of that activity is not liable for it. Now, there is a bit of a question of whether or not it's an obvious inherent risk, or if it's a risk that can easily and effectively be eliminated. So, for example, could you argue that a non-mitigated risk is not really an inherent risk because it could so easily be effectively eliminated? That's a debate for the lawyers. But ultimately, what is an inherent risk of an activity, and how would an operation establish that somebody's injury resulted from that activity's inherent risk? Well, the lawyers could always argue in court and prove that risk X, whatever it was that came into being, is an inherent risk of whatever the activity is. You know, that's certainly possible, and it certainly happens. But to be fair, that's kind of risky, and it might be difficult to prove depending on what the risk was and what the circumstances are. Now, you don't need any kind of liability waiver for that. That's just something that the lawyers would argue in court in your defense. But you can also explicitly tell the people that you're dealing with, your customers and whatnot, what the risks are, and they can confirm that you have told them that on the liability waiver. You know, those of you who have seen and actually read waivers, you know, often there's a section of those waivers saying, I acknowledge that there are many risks inherent in whatever the activity is, including, and then a nice long laundry list of things. And then the person signs that waiver acknowledging they have read it and agree to be bound by it. Now, of course, when you're doing a waiver listing inherent risks of whatever your activity in question is, you need to be pretty darn exhaustive there, and most waivers are. Now, looking at that second bit of something bad happening, that's the result of the host or their employee's negligence, you know, an act or omission, something they did that they shouldn't have done, or something that they didn't do that they should have done. Now, that's something that's not considered an inherent risk of the activity. It's specifically the negligence or the wrongdoing of the host or their employee. Now, if you have a properly drafted and administered waiver, that can be relied on as part of your defense to a claim, even if the injury that resulted was caused by you or your employees or your staff's negligence. Now, going back a little bit, well, what is a liability waiver itself? I mean, that's kind of the legal definition there, but at the end of the day, a liability waiver is ultimately just a contract. A participant in an activity signs it, pretty much always as a precondition to being allowed to participate in that activity. It acknowledges that there are risks involved in their participation, the inherent risks that I just talked about, and it releases the host or whoever is running it from liability should that something bad happen. Ultimately, a waiver is a legal defense in a lawsuit. If you and your operation get sued in court, your lawyer can wave around that signed waiver and say, this case should be dismissed because of this waiver. And properly drafted and administered, a waiver will cover injuries that result from both the inherent risk of the activity and also the negligence of the host and their employees. Now, are these things even worth the paper that they're written on? What do courts do with them? Well, generally speaking, it can be hard to get a court to uphold a liability waiver. Judges often find them to be invalid, or at least look for ways for them to be found invalid, either due to their content or the way in which they were presented and executed. And that's because waivers basically allow an operation to avoid responsibility for their own negligence and deprive an injured person of compensation for that, which courts are generally not happy to do. And what that means is, first, your liability waiver needs to be properly drafted and contain elements that previous judges and previous court decisions have said make them valid. But just as important, the waiver needs to be properly administered such that the customer has signed it or has seen it in circumstances that don't allow the court to say that they were not valid. And in both cases, we, as lawyers at least, looked at previous situations for guidance as to what judges have found acceptable or not acceptable. And we do our best to replicate that when we're either drafting them or advising you. And this is because of something that the lawyers call precedent. Similar court cases should be decided in similar ways. There's got to be consistency. So if you have a waiver similar to the one that was previously found to be valid by a court, odds are increased that a later judge in a later case will also find yours to be valid. So we as lawyers review commentary from previous court decisions to see what waiver elements that the judges were found to be good, and we replicate those, or bad, and we don't replicate those and figure out something better. And we adopt those elements. So, if you've seen waivers that have things like yellow highlighted red circled areas that emphasize key content as a means to flag to the client or the customer, whoever's signing that it's important and they should actually read it and understand it. If that's just not there for fun and to waste your printer ink, those colors are there for a reason. Places on the liability form for initials in various parts of the document as a means to show that the client or customer has read that section, or to at least acknowledge that they have been told to and should have read that section. All these are fairly key things that we as lawyers draft because previous decisions from previous courts have said they are important and why. And when done right, companies can rely on those waivers as a defense to an injury claim, even if the injury resulted from your own negligence. Now, I'll mention two quick cases out of BC to illustrate just the breadth and complexity of what we're dealing with when it comes to waivers. Suffice to say, it's not black and white. There's a lot of gray and there's a lot of nuance in these cases. So, I can never give a straight answer for a lot of the time when people ask me a simple question. The first case is low check. Now, this is a case of employee negligence, not inherent risk. It's a zip line business up at Whistler. The zip liner stalled midway down the zip line. Now, the employee at the top, rather than ensuring that the line was clear, negligently sent the next guest down the line. Now, that guest collided with the one that stalled at a fairly high speed, and that first guest was fairly seriously injured, and they sued the operation as a result for compensation. Now, I think it's fair to say that being hit by the next zipliner is not an inherent risk of ziplining, and the injury was clearly due to the wrongdoing, the negligence of that employee. Normally, it would be pretty clear that there's liability for that. But in this case, there was a waiver, and that waiver also released negligence of the operation. In court, the judge upheld that waiver, confirming that if properly drafted and administered, waivers can waive that operation's negligence. Now, to be fair, it also helped that one of the zipliners was a lawyer and the other one administered waivers for business. So arguably they kind of knew what those waivers were and what they had agreed to. Apps was a different sort of case, and we lawyers call it a ticket case. Now this was a ski hill, obviously, but the waiver was on the ski hill ticket and was posted at the ticket window and elsewhere at the ski hill. The client didn't actually sign any sort of waiver. But the law says that you don't have to have a signed waiver to be able to be held to a waiver. The operation just has to prove that the client's customer was aware of it and had agreed to it. Now, obviously, the best way to prove that a client was aware of an accepted waiver is to have them sign it. But strictly speaking, that's not required. You can show that the person was aware of the waiver by posting it conspicuously at your operation and having a term like, by proceeding, you agreed to be bound by it, for example. Now, Apps was a snowboarder, and he was injured on a terrain park feature at the ski hill. Actually, seriously injured. He was rendered a quadriplegic, I believe. And he sued for his damages. Now, again, he hadn't signed any waiver. And the question for the judge was, is it fair or reasonable in the circumstances for him to have been bound by either the posted waivers or the waivers that were on the back of his ski ticket? Now, the waiver in question was posted at the ticket window and was printed on the back of his ticket that he affixed to his jacket. There was also a specific warning sign about the risks of the terrain park that were posted right at the start or the entrance of the terrain park. Now, Apps claimed in court that he didn't read the waiver on the ticket and didn't notice the sign on the ticket window. At trial, the BC Supreme Court judge found that it was not realistic to believe that a person approaching the ticket booth would stop and read the sign. It was posted away from where the purchaser was focused on the ticket window where the transaction was occurring. Not only that, the waiver that was posted was hard to read. It was basically just one big run-on paragraph. And also the ticket seller was not instructed by the ski hill to say anything about the waiver to the purchasers and hadn't. So arguably not good substance or style when we're talking about that waiver. But there was also a sign on the terrain park entrance that was clear and easy to read. And also by coincidence, Apps happened to work at Whistler as a ski tech, and Whistler had waivers that were fairly similar in wording to Gross. One of his duties as a ski tech at Whistler was to witness customers signing Whistler waiver forms. So he had dealt with waivers fairly regularly. So in this case, the trial judge said the circumstances of the injured person were also factored in. So as a result of the terrain park wording sign and the plaintiff's experience with waivers, the waiver was upheld at the trial court and the case was dismissed. Sounds great and kind of makes sense? Well, that decision was actually overturned by the Court of Appeal when it was appealed. That sign at the terrain park that warned about the specific hazards at the terrain park? Well, by the time Apps had arrived there, he had already paid for his non-refundable ticket. He had already taken the lift to the gondola up the mountain and had already started snowboarding. At that point, the court said, it was far too late for Gross to have given him notice of what was in the waiver. That notice of what was in the waiver and what he would have been agreeing to had to be given at or before the ticket booth when that transaction and that contract when you purchased the ticket happened. Now, what about that sign on the ticket window that contains the waiver? Well, the Court of Appeal was left with the trial judge's factual findings, specifically that the ticket booth sign was difficult to read, that the own negligence section that the ski hill was trying to rely on was not highlighted or emphasized in any way, and it was unrealistic to believe that a person approaching the ticket booth would stop in front of the window to read the sign. Remember, it's posted way up here, and this is right here. What about Apps's previous duties at Whistler administering the waivers at Whistler? Well, as a matter of contract law, and remember, a waiver is a contract, it's only actual knowledge of the specific term in question through a person's previous dealings that is relevant here. Apps had never dealt with Gross and Gross's liability waiver before. It could not be bound by the own negligence clause in Gross's waiver simply because he had involvement with Whistler waivers that had a relatively similar clause. The fact that he may have had some previous awareness of liability waivers and the own negligence clauses at Whistler did not mean that he could have been seen to have waived his legal rights with respect to gross. His Whistler experience was not transferable to satisfy what gross needed to be able to do to uphold its waiver. So again, there's a lot of nuance here, and it's very complex. What is drafted in the waiver is key. Those yellow highlights, those red circle sections. Part of the Apps decision was that the attention of Mr. Apps was not drawn in any way to that particular clause. Had it been highlighted in yellow and ringed in red, rather than being part of one big run-on paragraph, that could very well have helped. But not just the content of the waiver, administration of the waiver actually helps too. Well, it's actually not more than helps, is key. You can have the best worded waiver in the world, but if it's not administered properly, it's not going to be worth anything, and it won't be upheld, regardless of how well it's worded. Basically, at the end of the day, you want to ensure that your customer, your client, has had a chance to fully review in an unhurried and no pressure environment your waiver. And if they've had that chance, the fact that they ultimately didn't before signing it, well, that is their own fault. So what should you and your employees / your operation do? Well, confirm the client is who they say they are. Make sure the person signing is actually the person who's actually the one who's participating, is the one who's paid for everything. Give the person sufficient time beforehand to read and sign the waiver before the event. Now that arguably extends to even sending, if you're, for example, doing an online booking, sending the content to them or having it displayed on their website before they can even click through to the actual booking page. Ensure that the person has completed the entire waiver, not just the signature at the end, but the sections where it requires initials. Beware of language issues. If the person doesn't speak English, the fact that they signed an English language waiver probably is not going to help you very much. It could very well be the case that you need waivers translated to specific languages if that is your demographic and that is a common thing. You or your employees or your operation should answer truthfully all questions that's asked. And also very importantly is to be consistent. In BC, somebody has 2 years after an event happens to sue, and then after that to file the documents in court, and then after that they have 1 year to serve or to give you the lawsuit. So theoretically, it could be 3 years after an event before you even learn that you've been sued. Now, I don't know about you, but I think it would be pretty hard to specifically recall a specific event and the specific waiver administration 3 years after the fact, or even longer by the time you actually start getting asked questions about it. So, Mr. Smith has signed a waiver and has gotten injured in your event and now he's suing for it. 3+ years after the fact, you're probably not going to be able to recall this specific transaction and testify about it in court where Mr. Smith was given the waiver and what he did or did not do. But if you're, at the very least, if you're consistent with your approach and your operation, then you can at least confidently say, while I don't remember this particular transaction, I can say with absolute confidence that this is our procedure. We follow it without fail every single time, and I have no reason to believe that the procedure followed for Mr. Smith was any different than the procedure followed in this procedure. So that's what you should do. What you shouldn't do is, well, pressure the person to sign it, exert what we call either economic pressure or time pressure. Economic pressure being, well, you've already paid the non-refundable $500 deposit. If you don't sign this, you're not getting your money back, you're not going. Or time pressure, everybody else is sitting in the car waiting to depart. We're waiting on you to sign this waiver, and you're sitting there flipping through 5 pages, reading every single word. We're waiting on you. Get going. Time pressure. Don't be rude, belittle, make the person feel inadequate because they either have questions, they want to read it, and obviously don't represent or say anything different than what's in the waiver. Basically, at the end of the day, you want to ensure the person has had a chance to fully review in an unhurried, no pressure environment. Now, the entire talk that I've given right now, up to now, about waivers should have an asterisk floating above it, because we need to talk about minors. And minors in BC is anyone under the age of 19, also called infants. You tell your 18-year-old at home that they're considered infants under the law. You often see in waivers the section for parent or guardian signature if the person is a minor. But does that do anything or mean anything? Well, as a general proposition in contract law, and remember, a waiver is a contract. Contracts can be enforceable by a minor, but they are not enforceable against a minor. So what does that mean? Well, there's a very surprising lack of previously decided cases about minors and waivers, and whether or not an operation can rely on a waiver signed by a minor and their parents and guardian. And at least in BC, the law is pretty clear thanks to some of our legislation. We'll talk about that. So Wong is kind of the key leading case in BC. It was a situation where a minor was injured in a martial arts training facility and sued because of it. Now in BC, unlike a lot of other provinces in Canada, we have a unique provision in one of our legislation statutes, the Infants Act, that's generally not found in most of the other provinces. And it specifically says that a parent can't bind their infant, and again, an infant is anyone under 19, to an agreement that waives the right to bring an action in court. So in other words, at least in BC, that parent guardian signature on a waiver that would waive the minor's right to sue for injuries kind of means nothing. And those waivers are probably going to be unenforceable if they pertain to an infant. So in BC, at least, waivers for minors don't work. Well, what about other provinces? Well, DeWitt was a case out of the Maritimes. A 15-year-old plaintiff was rendered a quadriplegic in a motocross accident. His father had signed a waiver on his behalf and they sued. And in defense, the defense relied on the liability waiver that had been signed. The plaintiff in that case, the injured person, brought a preliminary motion, in other words, before the full trial had a chance to start, to try to preemptively strike out the defense of the motocross facility that had said, hey, we have this waiver, you can't sue us. And they tried to do that, arguing that the waiver defense was bound to fail. Now, because of how the law works, because that was a preliminary motion and not the full trial, to succeed, the plaintiff had to show that the waiver plea, relying on the waiver, was a scandalous, frivolous, or vexatious plea. And that's generally because the courts are loath to strike out a pleading or a defense before a full trial can give that defense a full consideration. So it's a pretty high bar to strike out a defense on a preliminary motion before it's had a chance to be considered in trial. Now in DeWitt, neither side could find any previous cases that squarely addressed the issue of whether parents signing waivers on behalf of their minors would work or not, and if those waivers were effective. You know, they noted the Wong case out of BC, but that was decided based on that unique law in BC that I talked about. And since there was nothing in the past in the DeWitt case that was saying that those waivers were invalid, the judge couldn't rule strictly on the pleading that it was scandalous, frivolous, or vexatious, and allowed that pleading to stay in so it could be decided at a full trial. That decision was appealed, and the Court of Appeal agreed with the judge. Now, noteworthy, all the judges that saw that case refused to rule on the ultimate question, whether an infant waiver signed by the parent or guardian was effective or not. Because the way that law works, such a decision should really only be made in the context of a full trial and not on the preliminary motion that was being dealt with in DeWitt. And unfortunately, the DeWitt case settled before that trial could be heard, so the issue remains without the explicit comments of the judges. So while courts have generally not yet outright decided that waivers signed on behalf of minors are unenforceable as a general rule, except in BC where there's that statutory provision that has led to a clear ruling of unenforceability, given the general law of contracts and minors, it seems likely this is the ultimate result. You know, this is the opinion of the law reform commissions, which are basically a group of legal academics and senior and very smart people that pontificate of what the law should be in the future. Minors, as a general proposition, should not be prejudiced by their own parents being naive, is essentially what it boils down to. So what we have is a general proposition that contracts, and again, remember, a waiver is a contract, can be enforceable by a minor. So if the minor wants to hold the other side to that contract, they probably can, but they may not be enforceable against a minor. So you're trying to use that contract against the minor, they're probably not going to succeed. So given that, for anyone under 19, waivers are generally not going to be effective. How do businesses protect themselves when they're offering services to a minor? Well, the judge in DeWitt noted, but actually didn't provide an opinion one way or the other, two potential alternatives. One was an indemnity agreement between the parent or guardian and the business, and the second was a signed acknowledgement of risk form by the parent or guardian. Now, in an indemnity agreement, the parent or guardian agrees to reimburse the business, in other words, indemnify them for any damages or legal fees or anything else, or costs incurred in defending a lawsuit brought by their minor child for any injuries suffered during the activity. So in other words, the agreement says, I'm signing this, and if my minor child sues as a result of an injury suffered during this activity, whatever payout the operation pays, I agree to reimburse them. It basically deters the parent or guardian from suing on behalf of their injured child by shifting the burden of the loss, the dollars, from the business to the parent or guardian themselves. Now, interesting, there's old authority from the 1960s saying that those agreements are going to be unenforceable, and the law reform commissions have commented that such agreements are probably likely against public policy, given they're intended to discourage a parent from pursuing a child's rights. But to date, no legislature has specifically enacted any legislation that specifically prohibits such indemnification agreements. So it's kind of an open question still whether or not those would be upheld. Certainly, it's something that is baked into a lot of liability waivers, but their effectiveness is yet to be thoroughly tested in the case. What about an acknowledgement of risk form? Well, remember back 10, 20 minutes ago that a business is not liable for injuries resulting from the inherent risk of an activity. So an acknowledgement of risk form is a minor's parent or guardian acknowledging that there are risks inherent in the activity and agreeing to assume them. Now, that form doesn't contain any waiver language. It doesn't waive the operation's liability for their own negligence. The form only contains language showing an awareness and a conscious acceptance of the risks that are inherent in whatever the activity is in question. And it's unclear whether or not that would be successful. The Law Reform Commission of BC has opined that a parental acknowledgement on behalf of a minor is tantamount to imposing on the minor the wrongful acts of the parents, and has said that any such form should have no legal effect. And of course, in defense, your lawyer can always show an inherent risk in court in the usual ways, by showing by expert evidence or otherwise that the injury resulted from a particular risk that was inherent in the operation itself. But either way, this signed acknowledgement of risk form has not been tested in court either way, so it's still unclear whether or not it would be upheld. Now, regardless of all of this, when dealing with minors, there's probably going to be some use in doing the whole liability waiver and getting the parent or guardian to sign it regardless. There might be unaware parents or guardians who might mistakenly believe that the waiver is effective, meaning that they're unable to sue. And as a result, I signed a waiver on behalf of my kid got injured, I guess I can't sue, tough, even though that's not the case. Parents who are aware of the situation and their lawyers may not want to incur the necessary legal costs of such an action, given the kind of lack of certainty, at least in some areas of the law. It's generally a good idea to have an indemnity agreement baked into the waiver regardless. Maybe it might be effective even if the main waiver on the negligence side of things is thrown out for a minor. We don't know, but it's possible. But at the end of the day, businesses and their insurers just must be aware that there's potential risks when you're dealing with minors above and beyond the normal risks that you're dealing with. Now, what about COVID? I would highly doubt that any liability waivers pre-2020 list pandemic or contraction of severe respiratory infection as an inherent risk of a recreational activity. Now, it's untested as far as I know to date, but it's probably pretty doubtful whether existing waivers would cover liability resulting from COVID infection, because pre-2020 language probably just isn't going to be encompassing enough to cover the circumstance. But we don't have any precedents yet, so we'll ultimately see. New waivers that you might have seen drafted since the onset of COVID will probably include such language under the inherent risks, something like, infectious and communicable disease, including but not limited to COVID-19 contracted through virus, bacteria, parasites, and fungi, which might be transmitted through direct or indirect contact or the negligence of other persons, That's in the waivers I'm drafting now. Further, there are some operations that are actually using COVID-specific waivers on top of their standard waivers. And the COVID waiver outlines the nature of COVID, the symptoms, the risks, and makes clear that even though the operation is following the directions and the advice of public health authorities, that's no guarantee that the customer or the participant won't get infected. And that's especially used, from what I've seen, in those operations or those activities that require very close physical contact as part of the activity, and there's no other way to mitigate that other than masks, obviously. Now, ultimately, we just won't know until the court cases start, and surely there will be court cases, and then we can get some judicial precedent on what, if anything, liability-wise there is for COVID infection and COVID disease. All I can say at this point is every case is going to turn on its own individual facts, but will be governed by the general law of negligence, which is probably a topic for another day. I think it's fair to say, though, that public health guidelines will likely strongly influence whatever the standard of care is on this case or on any cases. So key takeaways for what we're dealing with here: waivers are a good thing. They will cover both risks inherent in the activity, or at least help you to prove that an injury resulted from an inherent risk in activity, but will also cover the stranger circumstance of the negligence of your own business or your own employee and the indemnities for that as well. They will likely be upheld in court if they're drafted well with an eye to precedent and administered correctly. And keep in mind, the ticket cases, waivers don't have to be signed, but if they're not, it must be abundantly clear that the customer saw it, had reasonable opportunity to read and consider it, and agreed to it. Minors are just an issue generally. Under 19 in BC is a thing. And that's just something you and your insurance company deal with. And as for COVID, well, we're kind of in uncharted territory still, and we'll see, because surely there's going to be claims arising. At the end of the day, best advice, talk to your lawyer, get some advice on what you're dealing with, and probably your insurance broker as well, because they're the ones that are going to be helping you line up the insurance coverage that you need. Happy to answer any questions that are arising. I will take off screen share here, and actually I don't have to take off screen share, and I can flip through questions and answers. So, pending any comment from Louise, I can just quickly look at the questions and kind of jump in.
Yeah, please do that. Got a few questions, and if anybody else has got some, just add them. We've got another 15 minutes to answer questions. Yeah,
sure. So first question here: if you sign a waiver on joining a club, do you need to re-sign when taking part in future club events? Sorry to give the typical lawyer answer, but it depends. And I think the ultimate answer is it depends on what was contemplated by the waiver and what the waiver covers. And I'll give a quick example off the top of my head. There's a case, and unfortunately I don't remember the name, of a hunting guide out of northern Alberta. The client in that case had signed a waiver, but the hunt was unsuccessful. I think it was a black bear hunt offhand, or black bear or moose hunt. They didn't bag whatever the animal was, and as part of the guarantee, the customer was offered a chance to come back the next year for another hunt. They came back the next year for another hunt, did not sign another waiver, got injured in that next hunt. The guide outfitter tried to rely on the waiver in question. The court found that the waiver was not operative because the waiver covered that one specific hunt, the first year one, not the subsequent year one, and the waiver didn't contemplate anything subsequent. So depending on how the club waiver is worded, if it's covering a specific hike, if it's talking about all activities of the club, it may be covering future events. I think it would be fair to say that best practices are waiver every time you're doing something. But if you don't do that, I suppose a waiver properly drafted, contemplating future events, could potentially cover those. How detailed do inherent risks have to be in your waiver? Well, arguably it needs to be covered. Whatever you have in your waiver should be what actually happens, or at least can be argued by the lawyers that it is encompassing. And if you've looked at some waivers, those paragraphs can be quite lengthy in terms of what the inherent risks of an activity are. So if you have explicitly said in the waiver what the risk was that resulted in the injury, fantastic. If you have something that could be arguable, sure. Generally, it's better to be more detailed than not, for sure. In today's digital world, or how legal are waivers that are signed digitally or by a checkbox if they have read it? As a general proposition, there should not be, assuming everything else is met, there should really be no difference between an e-waiver, electronically signed waiver versus an in-person signed waiver. Certainly, I'm seeing that a lot through various electronic platforms. Arguably, in some circumstances, digital waivers are superior because you can send the person the waiver long before your event. There's no time pressure. The person can sit at their computer in an unhurried environment, take their time to read through everything, ask questions if they have it. The waiver itself, you might actually have to specifically click through different sections before it reveals the next section, the next section, next section. So there's additional evidence that the person has arguably read and agreed with that section before they're presented with the next section and ultimately their signature. So there are many pluses to the electronic waiver. I'm not aware of any particular case where an e-waiver was challenged because it was an e-waiver as opposed to a physical waiver and it was found to be any different. So theoretically, e-waivers can very well be a good thing. How can a small business owner make it so that they personally cannot be sued, and what steps must be taken? More of a corporate law question, quite frankly, because there are ways to, for example, if you incorporate a business and the business is run through, or your operation is entirely the incorporated business and not you personally, that's one way to kind of arm's length yourself away from the actual operation. To be fair, and when people always ask me, can I be sued for X? My response is always, unfortunately, anybody can be sued at any time for anything. The ultimate question is whether or not they will successfully be sued. But even if you have incorporated a company and that incorporated company is the one that is running the operation and you as the owner are completely arm's length, you only own shares in the incorporated company and that's it, you could very well still be sued by name because, well, people just have to name you in the pleading. Ultimately, you would have many defenses for that. So there may not be a way to completely isolate yourself, but there are ways to protect yourself is the best way I can put it. Is it acceptable for an employee of the company or a volunteer to witness a waiver? Best advice for dealing with someone who doesn't speak English well enough to understand the waiver, blah, blah, blah. It used to mean you don't have it translated. Saying that you can't participate if they don't sign seems like it would be pressure. Okay, so in terms of witnesses, theoretically, I don't see anything wrong with an employee or a volunteer to witness the waiver instead of somebody else. Ultimately, the witness is there to validate that the person has had a chance to review and sign it and has read it, or at least had the opportunity to read it. Arguably, the employee is going to be there anyway, whether or not they sign it, because they're the ones presumably giving the waiver. So theoretically, there shouldn't be anything wrong with that. And then best advice for dealing with someone who doesn't speak English well enough to understand. There's really, to be perfectly safe, there's only really two options. One is prior to, make sure you have a translated waiver, not only translating the English words into whatever the language is, but mirroring the stylistic content, that yellow highlight, red boxed area. So that style has to be identical, just with the translation stuck in instead of the English. If you don't have that, you need I guess you would need someone who is an experienced translator who could go, unfortunately, word for word, line by line with the person, translating as they go along and getting the person to initial and sign as they go along. Saying that they can't participate if they don't sign is pressure, but if they don't sign it and don't agree to it, arguably your insurance might not even cover you in that circumstance. There might be a requirement in your insurance policy that every participant must have signed the waiver. And if they don't have a signed waiver, the insurance might not cover you. Something to talk to your insurance broker about. But if they can't participate, arguably, to be safe, you should be saying they can't participate if they don't sign. And in that circumstance, to eliminate pressure, you can, at the very least, refund whatever they've paid up to that point. Or hopefully, prior to, arrange with them in the booking process, either to get it translated or have a translated version handy. Next question was online waivers, are they acceptable? Pretty much already answered that. Generally, yes. Waivers for volunteers in parks programs. That's a little different because I think, and this is, to be fair, not exactly my area of law, but when we're talking about an operation's own employees and arguably even their volunteers, now we're getting into work safe BC territory for workers' compensation, which is different and distinct and its own regime completely as compared to customers or people participating in a non-paid event. So volunteers in parks programs may be covered under WorkSafe programs, in which case you'd have to consult WorkSafe legislation and WorkSafe requirements. Ballpark estimate for the cost of a lawyer to put together a waiver for a trail race. Depends on who your lawyer is, if they're experienced and they can draw upon their own precedents versus someone who's drafting completely de novo. Anywhere from 1 to 5,000. It would be a very rough guess to put together a trail race waiver or a waiver generally. Depends on the circumstances, depends on the activity in question, the nature of the participations and related issues. Are there differences between when somebody pays to use versus not paying to use? Theoretically, no. So theoretically, if someone's paying for Whistler Bike Park versus not paying to use a public trail maintained by a volunteer organization, ultimately negligence is negligence and liability is liability. I do think it's a fair comment that a judge hearing the case might be more sympathetic to the circumstance where there's a non-pay situation or a volunteer situation as compared to a pay-to-play situation. But that's sympathy as opposed to strict black letter of the law, one way or the other. Do the protections of the Occupiers Liability Act pertaining to recreational trails apply to minors? I actually haven't compared and contrasted the Occupiers Liability Act to the Infants Act, so I'm not entirely sure whether OLA would apply to minors or in what circumstance. The provision in the Infants Act that I quoted was specifically about parents or guardians waiving rights on behalf of their minors through signing liability waivers. So OLA might still be enforced, but unfortunately, I'm sorry, it's just not something I'm familiar with. If you want to follow up with that, send me an email at my work address and we can chat. What is the effect of having volunteers versus employees dealing with participants in events held by nonprofits? Well, if you're dealing with participants, that depends what you mean by dealing with participants. If we're talking about administering the waivers, there's really no difference. The waivers have to be administered the proper way, regardless of whether it's a volunteer versus a paid person who's administering them. In terms of duties to the people, participants being handled by volunteers versus employees, ultimately the standard of care probably is the standard of care regardless of who those people are, and the same negligence law would apply one way or the other. Again, there might be an argument, and certainly I can see defense lawyers making the argument regardless, that volunteers may not be held to exactly the same stricter standard that employees are because they're volunteers or because the operation is a volunteer nonprofit versus employees in a paid organization or a paid operation such as the Whistler Bike Park, for example. So there might be an impact. Strictly black letter, there probably isn't that much, if any, of a difference, maybe in the standard of care that they're held to, but maybe not. Otherwise, like say your lawyer would be arguing more on the sympathy side of things to swing the judge more in your favor, to find more in your favor. Is a waiver needed for allowing other users to use equipment and pay by donation? Well, it depends what equipment we're talking about and the circumstances, but let's put it this way. If there's a chance that the individuals in question are going to get injured and are going to sue, you are probably going to want a waiver, or at the very least something in place to protect yourself, be it insurance or something else. So if the equipment could theoretically fall apart, not be maintained well, or at least the person who's using it would argue that it wasn't maintained properly, would fall apart, or they got injured in some way because of the equipment, or they were never taught the proper use of the equipment or anything like that, and they sued you, but would you want to take the chance that you're dealing with a situation like that without a waiver? How would you approach volunteer program that involves youth outdoors? They're on a beach or a dock and handle some live animals. Volunteer contract that makes them aware of risks going in, but we don't make a waiver. But would you think, what's the best approach? Well, again, dealing with minors, and again, minors, anyone under 19, so even 18-year-olds and 17-year-olds and your 16-year-olds who wouldn't be there considered an infant, even though they are. Yeah, what are best practices? It's a concerning area of the law for us defense counsel because there's either specific provisions that say parents, adults can't sign away on a waiver, and then there's a lot of strong suggestions in the case law and the surrounding law that basically says you can't contract yourself out of it. Best practices, as far as I'm concerned, waiver might be a good idea anyway, just to, warn them off a little bit. Acknowledgement of risks, potentially a good thing for sure, because it might help you down the road. Anything you do to make them and their parents or guardians aware of what's going on, potential risks that they're facing, could only be a good thing. You can try to bake an indemnity agreement into any kind of agreement that is signed, but whether or not that's going to be upheld is still an open question. Ultimately, I can't give a lot of comfort there when dealing with youth, unfortunately. It's, you can use a waiver, probably not going to be upheld, but pretty guaranteed it's not going to be upheld, but there might be some use in it anyway to scare off the people that don't know any better. You can use a signed acknowledgement of risk form, which might or might not be useful because of what the previous authorities have suggested. You could use an indemnity agreement, but the exact same points there, but it may or may not be useful. How long of a waiver, next question. How long of a waiver is too long? That is a good question. Yeah, it's a bit of a balancing act between you want everything in there versus you kind of want to be able to make sure to be able to argue at the end of the day that the person actually read everything or had the opportunity to read anything. I could certainly see a judge looking at a 20-page waiver, regardless of how well it's written, and regardless of how much time a person had to actually read it before an activity, and say, you cannot possibly expect a normal person to flip through and read 20 pages of legalese. There's no way. So a delicate balancing act between containing what you need to contain and not being too long to give, the argument to the contrary. Again, I'm giving the unfortunate lawyer answer of it depends to a lot of these questions because so much of this is not black and white, and so much of it depends on the circumstances of the individual issue at play and what the lawyers can argue. Dirt Bike Club sells annual memberships online on a family basis, makes it challenging for spouses signing the waiver for each other and their kids. Should we switch to individual memberships rather than family? Well, I'm not necessarily going to tell you one way or the other for that, but I think it is fair to say that anyone covered under the family membership should have signed a waiver, even the kids, even though the minors thing, you know what I'm saying about that. So both spouses, all the kids. I've certainly done waivers where I have more than one signature block at the end of the waiver, and everybody is required to sign and then initial in the appropriate places elsewhere in the waiver as well. So it might be good to have individual waivers at the very least, but theoretically a waiver that's got every signature blocks for everyone that's signed with everything that I've just said, administered properly, proper time and whatnot to sign it, probably okay. Do staff and or volunteers leading programs need to sign waivers? As I mentioned a couple of questions ago, when we're talking about staff and probably volunteers, we're now in WorkSafe BC territory, which is its own thing completely. My waiver talk is about participants in an activity, not the staff or the volunteers. Court-approved general waivers? I don't think so. I can't really say. All I can say is if you or lawyers take the time to review waiver case law, there are certain elements that are commonly seen and therefore replicated by us lawyers when we're drafting new ones. That number of slides ago, the example waiver that I threw up on the screen, that very top yellow highlighted red box, this is a liability waiver. You must read this. You are signing away certain rights, blah, 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 blah. That I think is fair to say should be on, and is pretty common on a general waiver for anything. Beyond that, there's nothing really general. there's certain phrases, certain formats that are helpful. So in that sense, could be maybe considered general, but there's no actual form where you can look up a general waiver online and you'll fill in this particular thing for your circumstance and switch that particular thing for your particular activity. There's probably not going to be anything like that. Realistically, you go to a lawyer that's dealt with these before, who's got a good bank of precedents, who can, use a general precedent, recycle 50, 75% of the content based on your unique activity, and switch in the specific things that need to be switched in. Sorry, I'm losing my track here. Does a waiver have to be witnessed? Does that apply to online waivers? Strictly speaking, probably doesn't have to be witnessed. Arguably, the witness is one that is going to be able to testify after the fact if it's challenged that, yes, this person signed it. Yes, I watched them read through it and sign it. And yes, I can testify as to that. But again, at the end of the day, a waiver doesn't even need to be signed. Remember the ticket cases. What has to be ultimately shown is that the person, if it can be shown that the person has had a chance and has read and reviewed and agreed to it. So witnesses are a good idea for sure. I don't think it strictly needs, and online versus physical in that context, I don't really think there's any difference. Are there any differences that should be covered off where First Nations are concerned? I guess I'm not entirely sure what you're specifically looking there. I mean, on First Nations territory versus not. Arguably, you'd want to make sure the release covers the First Nation or their government in question as one of the releasees, because certainly one possibility for lawsuits is sue everyone and sort it out later, and certainly suing the landowner or the land manager or the one responsible for the land, regardless of who's hosting the activity, is certainly something you see. So in that sense, the First Nation or the First Nation Development Corporation or the appropriate authority could very well be one of the ones who are listed as people being released in the waiver. If we're talking about individuals who are First Nations who are participating in the events, I don't necessarily, off the top of my head, see one difference or another that would make it different. Is there a difference between trip participants who are club members on a trip versus someone going with a private company? On the liability side of things, probably not. Again, if you're dealing with private for-profit company versus, not-for-profit club, the lawyer, at least in your defense, has the argument for more sympathy if we're dealing with volunteers in a not-for-profit versus a for-profit, money-oriented organization. But at the end of the day, there's probably not a lot of difference for the operation, and specifically for the waiver itself or for the participants in a trip versus, a private company versus a club. Arguably, I would expect the private company has probably got decent insurance, who are on the ball, who know the situations and have arranged for or got a waiver that is maybe a little bit more ironclad, maybe, but shouldn't be much of a difference one way or the other there. We lend out PLBs. Do we need to get borrowers to sign a waiver for this? Kind of the same comment for the one of my previous questions there. Again, is there a circumstance where you could potentially foresee yourself being sued? And as a result of that, if you are sued, having a waiver is generally a good thing. If you rent out a waiver, somebody gets injured, pushes the button, and either they've done it improperly because they haven't been trained, they do it and there's no satellite reception, and they didn't know that there needed to be satellite reception. The battery is dead because your operation didn't recharge it properly, or they didn't recharge it properly. And again, anyone can sue anyone at any time for anything, and the person injured may very well try to go after anyone with insurance or anyone with pockets to pay for an injury. It may very well be advised to have a waiver of some sort for that. What if you allow your employees and their family to participate in a river tubing activity? Do you still need to have them sign a waiver to be protected? The employees bit, that's kind of a nuanced situation. Are they employees covered by WorkSafe, or are they employees, but they're participating as a general member of the public in the place where they happen to work, but they're not working at the time? whether or not this is an employee perk. I'd say for the family members, absolutely, you need to get the family members to sign a waiver just like anybody else. And to be safe, I would suggest the employees would need to sign just like anyone else as well. Because again, just offhand, because I don't deal with WorkSafe type issues, I don't know if WorkSafe BC would cover a situation where your employee is participating in your activity, but not as an employee, just as someone who's participating for fun. For a large event, it would be acceptable to read the waiver to the group prior to beginning rather than have everyone sign individually. I'd say that would be risky only because how could you prove subsequently that everybody had a chance to consider and agree to it and ask any questions? To be fair though, that's not necessarily that different than the ski hill ticket waiver type cases, right? You know, what's the, again, I'm putting my lawyer hat on here. What's the difference between reading a waiver to a group and asking if there's any questions versus putting up a waiver sign next to a ticket booth window and telling someone to read it as they get their ticket processed? And there could be arguments either way. I would suggest to be safe, and as a defense lawyer who deals with this stuff, absolutely, I'd say have everyone sign individually. I wouldn't want to argue the defense case where the waiver was read to a group prior to, because, I mean, other than inflections with your tone, how do you highlight the particular nuanced and important bits that are yellow highlighted, red circled in the physical waiver? Possible, but risky. Is it necessary to pay for a lawyer to proofread a waiver or draft it? If you're talking about pulling something you found online and inputting your specific things, it's possible to have that upheld, certainly. It's risky because we as lawyers are doing this based on both precedent, what's been upheld in the past, and what are your particular unique circumstances and how can we meld those together. I've often said when operations or people approach me with here's something I've drafted, here's something that I found online, can I pay you to tweak it? I've often said it'll be much cheaper for me to start on my own with my own precedents after learning about your operation and drafting something, rather than taking the time to go through line by line to whatever you found or picked up and then tweak it. Because a lot of the time what you find online is not necessarily going to be up to date with what the law has said or is going to be helpful. So well, you can always try to use something, again, you found online or that you drafted yourself. Whether or not it's going to be upheld, well, you've seen in the handful of cases that I've summarized already how nuanced this area is. There's nuances that you're probably not going to be aware of. There's nuances that you might have covered. Who knows? Update. Hold on here. Can you talk a little bit about the definition of negligence and how that differs for organizations that are entirely administered unpaid volunteers? I'm going to very quickly back up on negligence. Hold on here. Where's my negligence bit? Give me a second here.
Ryan, we also going over time for you,
yeah.
So like, feel free to let do you just want to do this question? Like, it's really up to you.
Perhaps, yeah. Considering we're already almost 15 minutes over, and I apologize for that. How about anyone with a question that I haven't already answered? Please just send me an email, which is noted here, and I will be happy to discuss with you offline, rather than have everyone sticking around even longer. So I apologize for going over. As you can tell, this is kind of my thing and I get into it. So I'm happy to discuss with anyone offline, either phone call or email. Please just reach out to me and I'll see how I can help you.
Ryan, I think, judging just from all the questions, I think this has been a terrific, learning opportunity for all of us, for me too, for sure. So I really want to thank you for your time. And who knows, maybe we'll ask you to kind of come back in the future to kind of present on something else in this kind of realm of law. I want to thank everybody else, for coming. I know that some had to kind of leave a little bit earlier because we have gone over time. We've got a quick survey kind of coming up. It would be great if you could take a moment to kind of complete that to help us kind of put on better webinars in the future. It also asks about just, what else would you like to learn about? And then our next webinar will be on September 28th, and the topic is best practices for trail planning and management on private land. It's going to be a very exciting one. Our speakers will be Maggie Scullion from McElhaney and Stuart Spooner from Kootenai Columbia Trail Society, who I think is here today. And we'll send you all a copy of today's recording along with Ryan's slides. And I'll also just let you know about, I'll send you, make sure you get the registration link for the next webinar. So Ryan, again, I want to thank you. This has been hugely valuable, you know, I'm sure to everybody who attended. I'm so glad that you were willing to, you know, spend this hour plus with us today. So thank you very much to you, and thanks to everybody else who came along. We'll see you again, maybe next month. So thank you.
Thank you, everyone. Sorry for going over.
No, it's great. Bye, Ryan.